Hey guys, we are live. The court camera just picked up and started, so we'll get started. I am looking for the actual order reversing the Brian Steele appeal, the Glanville contempt. Brian Steele, Ashley Merchant, and his team were successful in appealing that. So we will look at that maybe on when they're bringing the jury out or something like that. It hasn't actually come down. But good morning. It looks like love is back in the courtroom, so sorry for those that don't want to see it. Shout out to those who want the entertainment. And good morning to everybody. I don't know why Law and Crime is being funky.
I didn't get any submissions from anybody. Do y'all have things to present?
Judge, with respect to the certified, it's 80322 that we were looking at, and I had an argument with respect to that analogy to the certified convictions.
All right.
Your Honor.
Yes, sir.
And good morning, Your Honor. Good morning, everyone. I did send a proposed jury instruction to this honorable court.
Okay.
But
I guess they haven't been forwarded on, maybe?
I mean, I could do that. I just don't, I usually do it to the
No,
honorable
I understand. You know what? She just sent it, so, okay. I'll take a look at those.
And I think that Mr. Abadi had some as well that he sent. I'll forward it to you.
Okay, yeah, I haven't gotten that, but I'm sure if it just came this morning, Ms. Percival will forward it on.
Not Captain Chaos is back. Hilarious. Let's get the squeak counter going. I guess Atkins now has the squeak. Oh, we got two squeaks. Atkins now has the squeak chair. All right, it's going to be a homework kind of quiet morning, maybe?
All right, and Ms. Lev, if you want to present your argument, go ahead.
Here we go, you guys. This is for the Rodalius Ryan certified conviction.
My understanding was that we were discussing the admissibility of certified conviction for a non-testifying co-defendant. And of course, the
Blaylock.
court is aware that
Maybe.
24-803-22
No, Ryan.
allows for the judgment of a previous conviction, specifically evidence of a final judgment entered after a trial or upon a plea of guilty, adjudging a person guilty of a crime punishable by imprisonment in excess of 1 year to prove any fact essential to sustain the judgment. And this includes judgments against the defendant for whom the conviction is being offered, but not the other co-defendants. Shall not be excluded by the hearsay rule, regardless of whether the declarant is available. That's 24-803-22. The prohibition in that statute is that it can't be used against the other co-defendants. And that is analogous, Your Honor, to a statement given to the police by a non-testifying co-defendant. That would be hearsay and would violate the confrontation clause of the other defendants. And so the way that the courts have dealt with those issues is that a limiting instruction, much like the one that I believe we presented to the court with respect to Shannon Stillwell's statement, has been given to the jury. And if we've not, my apologies, it was my understanding that we had. And that is what I'm forwarding to the court from Mr. Abate. Your Honor, also, as the court is aware, by way of analogy, I'm going to set the next example up. Overt acts are not necessarily even crimes. They don't need to be crimes in order to be overt acts that are said to further the conspiracy. Any overt act that has been committed by a non-testifying co-defendant, if we are to say that the unavailability of the person who is committing the act makes it a confrontation clause issue for any other defendants, then we would not be able to use overt acts in a conspiracy case against anyone. But of course, that's nonsensical. So what we do with respect to statements that do violate the confrontation clause or convictions of one defendant is that we give a limiting instruction, Your Honor. And so I would say that a limiting instruction and given 24-803-22 would suffice to allow us to introduce the certified conviction for Rodalius Ryan's murder. And I hope that I have not come in too fast and made no sense to the court.
Now I follow you. Okay, well, when I get the limiting instruction from the state, I'll take a look at that and the one submitted by Mr. Steele, because clearly that's what needs to be correct, because it's a complicated situation here. Does anybody else want to be heard on that issue?
Trying to get on my Lexus to see the statue. I'm having a little connectivity, slow internet issue.
It's slow, all right. I'm having the same issue. Good morning.
Hey, good morning, Your Honor. Good morning, Ms. Winfrey. How you doing, sir? Thank you for that stuff.
I did grab a steel clip thanks to Nosy Wren.
Oh, help me.
All right, let's not comment on the various attorneys.
Hello.
One of my favorite clips from this trial.
I thought I was waiting on the court. Your Honor, and I did as you ordered, requested, or suggested, whatever. And I worked on it a lot, and I hope it's helpful to the court. But I'd also like the court to take note. I think that everyone agrees on the law, so I'm not going into, there's a confrontation clause violation if there's no way that this court is convinced that the jurors will limit the use against the person who tendered the plea or the verdict was reached. But I ask you to consider also Henderson, Henderson versus State. It's 317 Georgia 66. Your Honor, it's in Division 4A as in Elisa. That's 891 Southeast 2D 884. It's 2023 case. And what it talks about, it's a Bruton issue. Mm-hmm. And it's the U.S. Supreme Court just came out with the newest Bruton case last year. And the issue in Bruton is what used to happen as a court, and I'm very familiar with the court's background. The court probably knows all this, but It used to be a limiting instruction. So a person gives a statement, there's a limiting instruction. And then the court said, yes, jurors are presumed to follow the court's instruction, and jurors under oath are deemed or presumed to follow the rules. But the court said, you know, sometimes it's just too much. So what happened then is Bruton became the rule that now we're going to redact any mention, direct mention, it could be influential, but any direct mention of another person on trial from the non-testifying co-indictee on trial's statement. So, testimonial statement. And here, that was my struggle the whole time. It's not as simple as this statement can only be used against a person, because this is deliberation time. And it's an overt act. Mr. Ryan's case that the court is entertaining right now and permitting to go forward is an overt act. And what you're going to say, I believe, is that if the state proves beyond a reasonable doubt that an individual, I'll just use Mr. Williams, willfully and knowingly joined a conspiracy with others, one or more, then all of the conduct of anyone in that conspiracy can be used against Mr. Williams. But here, you're going to have to, and that was my struggle, say, but not this overt act. So this overt act gets separated. And I know I've asked, and I believe the court is entertaining separate verdict forms for everyone. So that will assist. I say you could remove that overt act from a verdict form. But it's the deliberation. So the jurors presumably go back and deliberate. I'm just using Mr. Ryan's name because it's on the issue here. And they're talking about what's going on now in these several days of testimony. And then they're going to hear potentially the jury verdict. And then the jurors will be deliberating Mr. Williams and say, God forbid, he's part of the conspiracy. And then somebody's going to have to say, but now we can't use that verdict of that other jury, so let's erase that from our blackboard or our notes or deliberations. And I think that gets complicated. Then you're going to have the same issue with Mr. Kendrick. And, Your Honor, the predecessor judge denied our objections to this evidence, gave no limiting instruction, said he would deal with that later. He understood it was an issue, but deal with it later. And Mr. Stillwell's guilty plea, or pleas, I believe that there are several, have come in without any type of instruction yet. So that is going to have to be dealt with. And Mr. Nichols has at least one guilty plea, maybe more, but I believe one guilty plea that has come in the same way over the objection of timely objection, and the predecessor court stated that it would be dealt with later. So I don't believe at this point in time where we are, I tried my best. I did this several times. I gave you what I think is fair to everyone. I tried to be fair to Mr. Ryan and Mr. Kendrick in the instruction, but I don't believe, like in Bruton, I believe at some point it's just asking too much. So my objection is to admit the evidence since we're in a joint trial. Now, typically it's a severance. Severance would do it away, but you know, that's in the breast of this honorable court, but I'm not looking for a severance. I mean, personally, I'm just telling, I don't want to leave this jury right now. That's my issue.
Okay, so what you sent me, and I appreciate that, is about Mr. Kendrick's guilty, oh, I see,
I merged them, and I
It's the
understand it's now
same.
Mr. Ryan, so you're going to have to, if you like it or use
Okay.
any part of it, you're going to have to flip it.
Okay.
But I just gave both.
All right, and when do we expect, if it comes in, the trial conviction of Mr. Ryan to come in?
Your Honor, it may come in today, but if the court will permit, I'd like to also address something that I just heard said that I think is important with respect to the use of these overt acts against the other defendants. There's nothing in the law that supports the proscription on the use of those overt acts. In other words, like I said earlier, if it's an overt act that has been committed by someone else, there's nothing, even if it's a co-defendant who's not testifying.
But, I mean, I think the problem there is our confrontation clause problem. How do you get around that?
Your Honor, the same way, and we did also submit to the court a brief.
Well, I haven't gotten any of what you submitted. I don't know where it is in the ether, but maybe y'all could send that again.
Okay, we submitted a brief on overt acts. And
That I do have, yes.
okay, and that partially is addressed here, but previously with respect to the confrontation clause, in the same way that when we dealt with a statement given to the police by a non-testifying co-defendant, Your Honor, the courts have been clear that a limiting instruction is what is necessary. So if we are approving,
That's a whole lot different, though, than, I mean, I hear you saying that the fact of Mr. Ryan's conviction of murder is something that can be introduced against and used against as an overt act. All of these co-defendants, despite the fact that as to them, they weren't parties at that trial and so never got to cross-examine any of the evidence that is what resulted in Mr. Ryan's conviction. So how do you get around, that's a clear confrontation clause issue. How do you get around that and just be able to say, oh yeah, no, that can be considered against them as well in this trial?
Your Honor, I guess I would analogize it to, say, for instance, the posting by, I'll use, for instance, Diamante Kendrick of his picture saying Maniac is back on January 10th after Donovan Thomas is killed, right? So no one can cross-examine can cross-examine Diamante Kendrick.
But that's a statement by a co-conspirator.
Or the statement that Diamante Kendrick gave the police, or the statement that Shannon Stillwell gave the police.
That's not a
or
jury
any other piece of
conviction.
evidence. The point that I'm
She's
making
dull.
is that
She's dense.
evidence that is used to prove an overt act, which does not even have to be a crime. So
I understand that. Let's not go down that. Let's focus on the issues at hand.
evidence that is used to prove an overt act can be used against, in this case, under 803.
A conviction
8.
isn't just evidence.
803.22 or 803.22 can be used against Mr. Ryan, can be attributed to him.
Sure. No, nobody, I don't think, disputes that,
Right.
that it can be used against Mr. Ryan.
Right.
I thought you were saying you think it can be used against everybody else, despite the fact that it's a conviction. If used to prove anything against anybody other than the person convicted, is testimonial, and therefore presents us with a confrontation clause issue.
No, what I was saying was that it constitutes an overt act committed by Mr. Ryan. And an overt act does not have to be committed by.
I know, but how are you getting around confrontation clause?
Ask this
Because
question
it's
10
not- there's
times.
nothing for either of them to confront. It's an act that was committed by, if we use nothing else.
No. Okay.
Kind of
So
inherently
if
the
you
problem.
just, in this trial, reprove that he committed murder, although then the jury has to make that determination, then sure, that evidence, everybody gets to confront whatever evidence you present here. It can be used against everybody. If you say, here's a certified copy of Mr. Ryan's jury trial conviction
Then
for
this
murder,
jury is not deciding.
none of the other co-defendants got to confront the evidence that resulted in that conviction. So that's what makes it testimonial. It's here's the conviction. Here is this fact. It is established. And no one got to confront that other than Mr. Ryan, of course. So it's the conviction. It's here's another jury saying this is a fact. So if you don't use that, then whatever you use to prove it here Sure, that can be used against everybody because they all get to confront your evidence here in this trial where they are parties. Do you see the difference?
Your Honor, I do.
Okay.
Do you?
To a very large extent, and I'm
To a very
in
large
line with the
extent.
court. For the
Mhm.
most
So sit
part,
down.
I'm having a problem, and I hope that the court forgives me for that. With that last portion, the idea that it's a piece of evidence that they can't confront, and therefore the whole act can't be used against.
How are they gonna confront them?
By another jury of fact that they haven't been able to confront. So
if I,
how do you get around the confrontation?
Get Adam.
Issue? Yes, sir. And
I'm sorry.
is somebody going to send me what you proposed as a limiter?
I'll send it again, 'cause I
Okay.
And I apologize. I know I walked in.
Okay, it came through. Thank you. Yep. All right.
I just want
Yes,
to make
sir.
sure I'm hearing the court correctly, so we're all on the same page. So as it relates to the certified conviction, the limiting instruction would just relate to just that. But the evidence that we've presented here in court as it relates to the murder that Mr. Ryan and Mr. Blaylock were convicted of, the evidence that's been presented here in court today, we can argue that as it relates to all the defendants, correct?
That would be my position.
Okay.
I mean, don't know that anybody can argue against that. Now's your chance. But yeah, I mean, yeah, so yes, that is, everybody accepts that as the law. Even if they don't like
Except
it.
love.
And so, Your Honor, if much in the same way that there is a piece, for instance, someone admitted that they committed a crime, like Mr. Kendrick admitted that he and Mr. Arnold were going to go retaliate against a rival gang member. Say that piece, that fact is something that they cannot confront, but the overt act that they actually were going to go committed, that we show evidence of, all of that evidence is admissible against everyone. But Mr. Kendrick's statement, which they cannot confront, which is establishing a fact that goes to prove this overt act, they cannot confront it. And the courts have held that even in a conspiracy case, under those circumstances, that statement can be used with the limiting instruction. That's why I began with the fact that it's analogous.
Okay, so I think we're all generally on the same page about that. It's what does the limiting instruction need to say? That's what I. All right, so, yes.
I'm not on the same page.
Are you on the same page with what I'm saying?
I am, this is a little different in my mind. I thought I was on the same page, but that last statement, I'm not on
Well,
the same
you
page.
know, that's not the issue we're facing anyway, so it doesn't really matter whether we're on the same page about that. Are you on the same page? I mean, what I have said so far, do you agree that that's the law?
Yes.
Okay.
I think the difference is, and I think Mr. Steele articulated this as well, is when you have a guilty plea that deals with an overt act, that is a little different than a statement as part of the overt act, and it makes the ability to draft a limiting instruction that is workable exponentially higher.
I agree.
Okay, all right.
I agree. That's why I've been asking y'all basically since I took over this case to come up with something so that we could have something to work on. But of course, I'm getting it the day that the evidence is coming in, which frankly, it is not going to be able to come in before lunch because I'm not going to have time to sit and try to put it all together before lunch.
And
So,
Your Honor, if I may,
Yeah.
we don't have to even introduce that today. We can introduce that whenever the court tells us that, you know, we've had enough time to litigate it.
Okay, I appreciate that. All right, with regard to the